Welcome back to our update for examining the legal evolution of America's three major leagues. This is our Chapter 3 update. We'll defer to our baseball expert, Ryan, primarily here. This is Chapter 3. It's the creation of the antitrust exemption, baseball's antitrust exemption, through what I call the baseball trilogy at page 83 and following, federal baseball, Toulson, and then Flood v. Kuhn. And then, of course, we have the Flood Act at page 89. We'll go through this in some detail. But we're going to stretch the limit of how far does the antitrust exemption extend. That's at page 89 and following of the book. And one of the extensions is really cut off recent challenges at page 94 and following in terms of the minor league baseball players lawsuit in Miranda on an antitrust basis because I had to follow the San Jose case controlling precedent that's summarized at page 94. Antitrust immunity continued to protect MLB against an antitrust claim by the minor league players referenced at page 95 of the book. Then it gets extended, the immunity gets extended to scouts. That's the Wyckoff case at page 96. And really, during the class, we're going to be carefully exploring whether that's the better view. Is it just the reserve clause, or is it the entire business of baseball that is exempt from antitrust scrutiny? But against that background, there still are some pending Fair Labor Standard Act cases, which are not addressed in the book. Page 95, footnote 44 references them. And I thought it would be worth looking at this to probe the difference between state minimum wage laws in Florida, California, and Arizona, as the next to last bullet point talks about. And we've got the Save America's Pastime Act, which has made minor league players at the federal level as seasonal employees, but still we've got a split amongst the circuits as to whether a class could proceed for times prior to Save America's Pastime Act. So there's a lot going on here, and it really only is California, Arizona, and Florida. But Ryan, why don't you tease it out? We're taking a course in trying to understand baseball's antitrust immunity. How far should it extend? And why can't minor league players have standing under the Flood Act? They're not unionized. Why can't they have standing to sue for these claims still surviving motion and maybe going to the Supreme Court?
Yeah, so thank you again for having me, Professor Carfagna. And as far as minor league players are concerned, they are...
Is Ryan still on?
Yeah, I could hear you, Ryan.
Okay, fantastic. So as far as minor league players are concerned, the Flood Act does not cover them because it covers players on the 40-man roster, which is essentially, baseball has 25 active players. They have a 40-man roster of players that would be covered to be given standing. But this stretches back, decades, if not a century ago, to the Supreme Court creating this antitrust exemption for baseball, saying that baseball wasn't interstate commerce back then, and it took repeated insistence on not overturning that. So the league would not be subject to antitrust laws in any shape, form, or way unless Congress so chooses or so chooses to make them subject to it, which they did with the Flood Act, but only for players on the 40-man roster.
Right. And we've got a competing interpretation just class through Judge Scheinland's interpretation in Lauman and Garber at page 100 and following. Did the Flood Act really mean to exempt everything that's listed under the Flood Act, or did it mean to allow for the antitrust laws to operate in other parts of, right? And we have exceptions to that antitrust immunity. But as things stand now, the idea of a minor league player having antitrust standing under Miranda at page 95, is that really why they have to go the FLSA route to have any relief at all?
Yeah, the Flood Act could reasonably have been interpreted to bring a lot more into antitrust scrutiny, but that's just not the prevailing view at this point. It's the prevailing view that most of the business of baseball, quote unquote, is still exempted. So aside from things that directly affect the 40-man roster, MLB still is not, in most cases, not facing antitrust scrutiny.
We'll explore this in greater detail. How can the league be sued? Where are they not immune? And we have a study guide on that, which we'll get into. And that's the Silverman and Salvino and Salerno study guide, which we'll get into in some detail in chapter 3 when we look at how far does this extend. That's at page 114 and following. And that'll lead us into the non-statutory labor exemption, which again, just to anticipate that, Ryan. So once we have collective bargaining, once we have the unionized players and the collective bargaining relationship with MLB, then that really determines why it's exempt, because it's been collectively bargained.
Yeah, but even outside baseball's unique antitrust exemption, it has a non-statutory labor exemption for basically everything regarding players. So when a union and an employer, in this case MLB, come together and collectively bargain, they will not be held to account to antitrust laws, because that was the whole purpose of labor laws, was to encourage collective bargaining agreement. So that's the court trying to make both laws effectuated at the same time.
Terrific. Okay, and the last update is MLB's plan to eliminate 40 teams, shrinking the minor league system from 160 to 140 teams. They have their good reasons. This is not collective bargaining. It's the minor leagues against the major leagues, as it were, in terms of renewing the professional baseball agreement. And again, you just wonder, given San Jose, in which cert was denied, and Judge Kaczynski had a very expansive interpretation of the business of baseball. Basically, it's just page 94 of the book. It's going to apply to franchise relocation, and it really expands to include, under Kaczynski's reading, the entire business of baseball. What do you think could happen if there were a contraction and 42 MILB teams could be contracted? Would there be a lawsuit, standing for a lawsuit, or would antitrust immunity protect MLB from liability? That's our last bullet point in terms of our update.
It seems very unlikely there would be standing for minor league players. I mean, you see this with the HR 6020 that's referenced. Even Congress seems they need to do something about it. They're trying to pass a bill that would have government review of the contributions of minor league baseball, basically in essence to slow down and bring pressure to baseball not to do this. But also, I mean, you saw it with the COVID updates that MLB unilaterally canceled minor league seasons. And based on, like, as you referenced, Kaczynski's broad interpretation of what is the business of baseball, which minor league teams seem directly affecting that, past MLB actions and even Congress's almost, preemptive strike against this, it seems widely accepted that baseball will be able to do this, at least without legal recourse for the moment.
Terrific. Okay, that's a quick update on Chapter 3. We'll have some great guests to talk about the status, as we then find it, of MLB. We know a lot of games canceled. The Cardinals aren't even close to catching up yet. And COVID will be a big part of what we'll be looking at with our guests in week 3, as well as further updates to baseball's antitrust exemption. So with that, we'll close out this Zoom update, and thank you for your continuing attention to these updates, and we'll look forward to seeing you on week 3, module 3, with some great guests from MLB and MLBPA, and a good agent friend of mine named Joe Rosen. We'll talk about the individual players' situation in this COVID world. Thank you very much.